Okay, let's go on the record on cause number DC 2014220, Paul Sorrells versus George Clayton Allen, Valerie Lohr, Joel K. Thomas, and Joe's Creek Walnut Crime Watch Association. Counsel, make your appearances.
Brett Payne for Valerie Sorrells. And I should add that my associate Beth Shearer is also on the call, as she has done most of the legwork in preparation for this motion.
Okay, and you represent Valerie Sorrells, you said?
Lohr.
Lohr, okay.
Lohr, yes.
Okay.
Your Honor, Nina Salom, appearing for defendant Joel Thomas.
Harold Cook as well for Joel Thomas, Your Honor.
Your Honor, Mary Nix with the law firm of Holland and Knight on behalf of George Clayton Allen.
And Paul Sorrells for myself.
Okay, let's go ahead and proceed.
Your Honor, we actually have two separate motions. We have filed a motion on behalf of Ms. Lohr, and there is an additional motion. I don't want to step on anybody's toes, and so to the extent you would hear one versus the other and wrap up with the other, it's fine with me to either proceed first or second. We filed first, but I'm certainly willing to share the floor. So however the court wishes to proceed is fine with me.
Okay, I'm flexible. Why don't you guys choose however you want to do it? I'm okay either way.
We're okay with letting counsel for Valerie Lohr go first.
All right, Judge. Well, then may I proceed?
Okay.
All right. Judge, this is a motion to dismiss based on the Texas Citizens Protection Act, which is Texas version of an anti-SLAPP act. As I'm sure the court is well familiar with these types of motions, I would suggest and contend to the court that this particular fact pattern is set up, it just falls completely in line with the purpose of that statute. What is, I'm not sure how much the court has reviewed the motions in advance of the hearing. I don't want to regurgitate things that the court's familiar with.
No, go ahead.
Okay. The background of this is essentially a neighbor dispute, to put it in the most simplistic terms. What occurred here is that Mr. Sorrells and Ms. Lohr and her family were next door neighbors, and some of the co-defendants in the case were also neighbors in this area of town. Mr. Sorrells conducted a series of parties involving more than 40 people, mostly beginning on Sunday afternoons and continuing well into the early morning, and disrupting the neighborhood. This all occurred in 2020 in the spring, summer, and fall of 2020 during the pandemic, and during such time as Judge Jenkins issued orders prohibiting specifically those types of actions. This is specifically a CPA appropriate motion to dismiss, because what specifically occurred here, because she was concerned with her family, with the neighborhood, with the sleep of her children, with the sleep of herself, Miss Lohr did make several noise complaints to the City of Austin Police, along with other neighbors. But more specifically, on September 22nd, 2020, Miss Lohr wrote a letter to Mr. Sorrells' landlord, specifically addressing, to paraphrase, and the letter itself is part of the motions, and it's located several places in the motion and the petition. But in sum and substance, Miss Lohr wanted to make the landlord aware that Mr. Sorrell was hosting these large parties well into the evening with techno music and in excess of the social distancing guidelines, and wanted the landlord to know this in advance of any lease renewal. She did not suggest to the landlord that they breach the lease agreement, just that they need to be aware of it. Exactly 1 week later, Mr. Sorrells filed a lawsuit against Ms. Lohr and others, specifically trying to do what the CPA suggests we do not do, and that's a retaliatory litigation specifically set up to stifle, stop, and suspend free speech. The CPA applies because this was a matter of public concern. Again, we're in the middle of a pandemic, and if someone is hosting parties of 40 or more in the middle of a pandemic, it is a concern. It is a community concern. The health and well-being of her family and her neighbors also meet this definition. And so the litigation was clearly filed in response to that letter, given its timing. And that's specifically why we are here, to dismiss allegations of that type, of this type, to prevent.
Are you moving to dismiss the entire case or just certain causes of action?
Well, so that's where our motions are a little bit different from co-defendants. As it relates to Ms. Lohr's, the causes of action specifically asserted against her, I would contend that it applies to all. I suppose the argument to the one cause of action to which it may or may not apply, although I don't think Mr. Sorrells can carry it forward otherwise, is potentially the cause of action for civil conspiracy. There are, by way of his latest petition, he asserts 5 different causes of action against Ms. Lohr. And it is our contention that the CPA really applies to all, but in response specifically to your question, if any kind of argument was to be made, it would be this last minute civil conspiracy allegation that Mr. Sorrells asserted in a later petition.
And do we all agree that the new version of this TCPA applies and not the old version?
That's certainly our contention.
Is that correct, Mr. Sorrells?
That I don't believe the TCPA applies at all.
Okay, but from a timing standpoint.
That the one that was revised in 2019.
Right, it's applicable to this case.
That would be the one that would be applicable if it.
Okay, if it applied.
Yeah.
Go ahead, Mr. Payne.
Yes, sir. And so it is to address the allegation specifically. Mr. Sorrells has most recently alleged that Ms. Lohr committed or participated in a civil conspiracy by way of her actions. Mr. Sorrells has admitted in his pleadings that he has never met Ms. Lohr, would not recognize her if he saw her in a room, although in a later petition he suggests that he saw someone in a dark shadow that he suggests is Ms. Lohr, but nevertheless, never met her, never laid eyes on her, wouldn't recognize her other than in a dark shadow, has presented no evidence to the court, any kind of specific intent.
Isn't it true though, some of the things you're trying to do here may be ripe for summary judgment, but really are not TCPA issues, correct?
Well, if an argument like I suggested earlier,
because surely a stalking claim is not going to be subject to the TCPA.
Well, and the stalking claim is no longer asserted against Ms. Lohr.
Oh, has that been non-suited?
Actually, no. Sorry.
Has it been, Mr. Sorrells? Have you non-suited the stalking?
There are no new allegations or old allegations other than the malicious prosecution against Lohr, but nothing's been non-suited, and all it was more clearly defined in the Second amended petition that's been verified, and Mr. Payne is arguing off non-live pleadings, so I'm not sure how to.
So what claims are currently against Ms. Lohr?
She has 5, I believe. And
Stalking's not one of them?
Stalking is not one of them.
So what are the 5 against her?
Well, right now, stalking is not one of them. We don't have The civil conspiracy talks about she was involved in with Mr. Thomas the night that he was stalking. He was physically in the alley. She was physically in the alley. And they had coordinated and combined their efforts to commit this stalking offense that later resulted in the assault in the alley by Thomas. So to the extent that she is an accomplice to those criminal acts, yes, she's
Okay. So civil conspiracy, what else is against Miss Laura?
libel, malicious prosecution, intentional infliction of emotional distress, and you have to review the other one. How many is that? 4?
That's 4.
Tortious interference.
Tortious interference. Is that the 5th one, Mr.?
That's correct. Tortious interference.
Okay. All right, go ahead.
All right, so Judge, let's skip over civil conspiracy. Let's address, if with your permission, I would next address malicious prosecution. So once Ms. Lohr has and did raise this motion to dismiss, it is the burden. Burden is on Mr. Sorrells to now present clear and specific evidence of each and every element to support a malicious prosecution claim. That has not been accomplished either in his response, which is untimely and we can address at an appropriate time, nor in his live petition. Again, the malicious prosecution claim is specifically one of the concepts and claims, number one, that's otherwise protected as a free speech right, but is specifically incorporated into the CPA. What happened here was Ms. Lohr did in fact make several noise complaints along with other neighbors and called 911 in response to these early morning hour parties. And with the encouragement of 2 Dallas police officers, did sign her name to a citation once those police officers inside of her home verified that the noise complaint was valid. There is a presumption under malicious prosecution that someone like Ms. Lohr acted reasonably and had probable cause. There's case law that addresses this out of the Dallas Court of Appeals, that there is this presumption under the CPA. Mr. Sorrells must also present evidence that to support a prima facie case that she was not acting reasonably. He must present competent evidence to overcome the presumption that she had probable cause to act. It is our contention that he has not done so by way of his untimely filing, and even within the content of his untimely filing, and accordingly, the claims for malicious prosecution presented by Mr. Sorrells are untimely. Must be stricken under the Texas CPA.
Okay. Is that everything?
No. Likewise, Mr. Sorrells has asserted a tortious interference with contract, cause of action against Ms. Lohr. Again, this is the letter to the landlord. The letter does not request or encourage that the landlord breach the lease agreement, just suggests, here is what's going on in this household. Perhaps you should investigate before renewal. The contract was not interfered with because Mr. Sorrells is still living there. There has been no breach of any lease agreement, and so no actual damages. Again, the content of Ms. Lohr's letter is sum and substance what is incorporated under the CPA. She is addressing to the owner of the property a matter of public concern, that is, all night parties in the time of COVID, not keeping social distance, alcohol involved, potential physical injury, all of those things of subject of public concern, general concern, and therefore should be dismissed under the CPA. Likewise, Mr. Sorrells has asserted a libel/defamation per se claim against Ms. Lohr. Nowhere in his response does he present evidence that Ms. Lohr's statements injured his personal reputation and thus exposed him to public hate, contempt, or ridicule, financial injury, or impeaches honesty, integrity, virtue, or reputation. Also, Mr. Sorrells has presented no evidence that Ms. Lohr's statements were false. Nowhere in the original amended or second amended petition or in the response does Mr. Sorrells deny that he was participating, hosting these all-night parties in the time of COVID. And so both under the CPA and otherwise, Ms. Lohr's statements are protected as a matter of public concern, and that claim for libel/defamation should be dismissed as a matter of law. The same would hold true for the final allegation against Ms. Lohr, and that's intentional infliction of emotional distress. Number one, and recognizing that's really more of a summary judgment argument, but at the same time, it's also applicable here because once Ms. Lohr has asserted that the IIED claim is subject to CPA, Mr. Sorrells is required to present evidence that, in fact, that the IIED doesn't apply here, and that there is evidence, even a prima facie case, of evidence of outrageous and extreme content going beyond all possible.
But again, that's not really a TCPA issue, is it? I mean,
well, but the IIED is based on these protected statements by Ms. Lohr, so it does apply. Because Ms. Lohr has asserted that those statements are protect her from an IIED claim, and accordingly, the CPA does apply, and Mr. Sorrells hasn't presented evidence to the contrary.
Okay, I don't think I see that, but okay. Anything else, Mr. Payne?
Not as it relates to Ms. Lohr. Those are the allegations.
So in your original TCPA motion, there was I think 10 causes of action, including nuisance and some others. I guess the rest of those have been non-suited out or amended out. Amended out,
yes.
Okay. Okay. How do you guys want to do this? Why don't you, I guess, respond to that, Mr. Sorrells? And there was a Mr. Akins that just signed on. What are you here for, sir? You're muted, sir. You're muted. Mr. Akins, you're muted. You're still muted. Is he here on this case or something else? Does anyone know who he is?
No, sir.
Judge, I'm here for the next case.
This is the last hearing, I think. What case are you here for?
The Cook versus Wayne case.
Let me double check. I thought this was the last hearing today. Let me see.
It was scheduled by Rhonda last week.
Maybe I'm wrong. Let me see. I don't see what time is it supposed to happen.
3.
It's not still on the docket, so you might want to call Rhonda or Rose and just see what's going on. But it's not currently on the docket.
All right, sorry.
That's okay. All right, Mr. Sorrells, do you want to respond to Mr. Payne?
Everything is I think laid out clearly in my response. He went into some non-live pleading issues so I don't really know how to. I think the court would find my response to be clear and specific to the instances here. So.
Well, why don't you do this? There's been a lot of amendment of pleadings and things like that. So, and then it seems to be some in your response, some overlap between what Ms. Lohr did versus what some of the other defendants did. So why don't you kind of humor me and make your argument as to Ms. Lohr in particular?
Okay, so Ms. Lohr in particular, she procured a prosecution that would not otherwise have been procured for a noise complaint that was summarily dismissed by the City of Dallas Prosecutor's Office almost immediately after a pretrial hearing, because there is no evidence to it. There was no evidence to any aspect of it. I have had 3 meetings with Dallas police commanders and jointly with City Councilwoman Gates. And they have stated that there was no noise complaints. Their officers have constantly stated there are no noise complaints, but Alan Thomas and Lore have worked together. And this is not about them calling the police, even though that is annoying and harassing. They went further. In fact, Lore's letter to the landlord does not just say, oh, in case you're interested in knowing of this, she mentions COVID in a brief second, but that's not the basis of the letter. The letter is very clear. It's very libelous. The intent is clear to what she's doing. She even throws in the illicit use of drugs, which is absurd. And so, she via text message and telephone call conspired
on what page there's 300 and something pages of exhibits here. What page is the letter that she sent?
That would be, are you looking at
I'm looking at your response.
Okay.
Or if you want to share screen. Oh, is this it? I see it. Okay. Is it set on September 22nd, 2020?
Yes, sir.
Okay. So it's page 142 out of 342 on the PDF. Okay. I read the letter now. Okay.
Okay. And so they, on the night of July 25th, Ms. Lore, in conjunction with Mr. Thomas, Mr. Thomas came over, quote, investigating loud music to my house, into my alleyway, climbed to my fence, came into my driveway to my back gate, which is 24 feet from the alleyway. So 24 feet onto the property to videotape and audio record my pool and windows in the open back door. And when I happened to come upon him while I was walking my dogs, he panicked. He implicated Miss Lore in his scheme there. I called 911 while I was talking to him. As soon as the police were dispatched, he panicked and came straight at me, which is an assault. And then we got into an altercation. I took him down to the ground there in my driveway, and Dallas police arrived emergent with the lights on to handle him. And Miss Lore was also out there in the alley. And at which point he was detained, and an assault charge has been placed on him and is pending currently in the City of Dallas courts. To the extent that Ms. Lore, the letter I think is pretty clear as to her intent and her actual wording of it. And as far as that goes, I stand by everything here. I'm not sure when someone does this to somebody, what other alternative there is. My patience just wore thin over months and months and constant doing this. And it's escalated and escalated. So besides shooting each other in the alley, I'm not sure how you deal with this other than a lawsuit.
I'm not encouraging you to do that. That's for sure.
I'd not like to do that.
No, we're governed by, sometimes we have folks that forget this, but we're governed by a rule of law. So,
and that's the only reason that I'm here is that it's the civil way of handling their uncivility, their incivility. So.
Okay, let me hear the.
Your Honor, briefly,
Sure.
I don't know if I'll have another opportunity to speak. And so you asked if I had anything else. I do think technically on the record, unless I'll be given another opportunity, but I need to assert formal objections to the response for being untimely. And then I
Okay,
have
good.
specific,
Explain why it's untimely.
because because Chapter 27, the TCPA Act requires a response on or before 7 days, and this was filed 6 days before. But more specifically, I have several objections to the specific evidence in the response. Primarily, there are Mr. Soros relies on, or there are 61 different paragraphs in his second amended, the live petition, that he purports to rely on, that are just simply conclusory statements. And there is case law that's out of Dallas County that states that you can't rely on a verified petition for that purpose. And even if it were the case under the CPA statute, I still need to raise objections to any conclusory statements, of which there are at least 61 in that petition. I also have some objections to some of the other unverified evidence. I'm happy to take it up later so long as I'm given the opportunity, but I do need to voice it on the record.
And Your Honor, counsel for Defendant Thomas would like to reiterate those objections as well.
Okay.
Based on the same case law, well, it's simply a verified petition, which is not enough.
All right, let's deal with the other TCPA motion. Ms. Salam, are you going to argue that one?
Yes, Your Honor.
Okay, go ahead.
Your Honor, again, Nina Salam on behalf of Defendant Thomas. We are here today based on, again, a neighborhood dispute, okay? I do want to reiterate the fact that all of this took place during a time of much tense and it just everyone was extremely very tense and
So before we jump into this, because there's been all these amendments and everything, which claims are still actively being sought against your client?
Well, per the second amended petition, it would appear that plaintiff Sorrells removed the nuisance claim, and he essentially kept the stalking harassment claim, which was lumped in with this. It was stalking and harassment, which all ended up being lumped into one claim. He kept the civil conspiracy claim, and he kept as far as Thomas goes, he kept the defamation per se claim, invasion of privacy, intrusion upon seclusion, and intentional infliction of emotional distress.
And assault.
Our motion does not address the assault. We're confident that will be summarily dismissed once the criminal matter is resolved.
That's not being dealt with now in the TCPA.
No, Your Honor, that will be summarily dismissed once again the criminal proceedings, and there's been no evidence produced by the city in any way, shape, or form. There wasn't even a report made that day. It's my understanding that Mr. Sorrells made, as he stated himself, many communications with the police officers on the night of this.
I don't need to hear argument on this. So so these are what's listed in your motion. Stalking harassment is still live. Civil conspiracy is still live. I guess harassment is combined with stalking harassment. Is that right or no?
Yes, sir.
Okay. So harassment is out as an independent claim. Tortious interference with existing contract, is that still in?
That's with lore only.
Okay. That's lore only, so it's out as to Thomas.
It was never against Thomas.
Okay. Defamation per se is still in, is that right?
Yes, sir.
Invasion of privacy, intrusion upon seclusion, is that still in?
Yes, sir.
And nuisance is out, and intentional infliction of emotional distress is still in, correct?
Correct. Based on my research, nuisance is more of an injury, not a cause of action, so it was removed.
Okay. All right, Miss, you may proceed.
I would like to make one comment with regard to the comment just made by plaintiff. He stated that based on his research, nuisance is more of an injury. Your Honor, all of these causes of action require, between the burden shifting, that plaintiff provide clear and specific evidence of the essential elements. These causes of action, one of the essential elements, all require a proof of injury, damage. And so I'm going to elaborate on that later here in a second. But again, he just said himself that based on his research, a nuisance claim requires injury, meaning that he took it out because he had no injury. And
it doesn't matter to me why it's out. It's out. So
okay.
Let's deal with what's what I have to decide today.
Yes, Your Honor.
Yeah, the nuisance is an injury. That's
Guys, it doesn't matter. Let's move on to the live pleadings.
And so, Your Honor, I'll try to get through this as quick as I can. But again, there are so many causes of action that were asserted against my client that it might take a second here.
Okay.
I would like to start by reiterating some points made by counsel for Valerie Lohr regarding the purpose and intent of the statute. Your Honor, the purpose and intent of the statute, as represented through the case law throughout the years, and even with regard to as of the 2019 amendments.
Let me ask a quick question. Under the new statute, when is my decision due on this?
It would be.
And is it the same for both?
I believe it's the same for both, but let me just confirm here. 27.004A must be said. I'm sorry, 27.005 ruling states that the court must rule on a motion not later than the 30th day following the date of the hearing.
Okay, so I have 30 days from the date of the hearing. Okay.
That's right. And so again,
Go ahead.
Sorry. And again, Your Honor, I'd like to reiterate the purpose and intent of the statute. The statute itself.
Yeah, I've spoken on the statute many times. When I was in private practice, I actually lobbied on the statute. I've actually even done presentations on the amendment, so you don't need to go into all of that. Just let's get to the meat.
Okay, I'll get to the meat then. And so to begin with, here, the statute is clear that a motion to dismiss under the TCPA may be brought when, with regard to claims against the defendant that are based on, relates to, or is in response to the party's exercise of that constitutional right. Okay, and so it's important that we look at the evidence and the claims that the plaintiff has brought forward.
So let's talk about the stalking harassment. So the stalking harassment is based on what exactly?
Your Honor, the stalking harassment claim is actually based on this July 25th night. Okay, it's the night of July 25th, where plaintiff states that he was he's actually made contradictory statements where he puts himself coming from two different ways of the alley. But whichever way he decides to stick, whichever version he decides to stick to of his story, that is one of the pieces of evidence that plaintiff has brought forward, is this night of July 25th, where plaintiff states he was walking his dogs and he happened upon my client in the alleyway. Okay, Your Honor, the plaintiff, my client, and Miss Lohr, they all shared the same alleyway. And it is public property. No one owns the alleyway. Everyone needs to access the alleyway in order to get to his or her home. On this night, plaintiff claims that he was returning from walking his dogs when he happened upon my client in the alleyway. There's a lot of conjecture and vague allegations, but as far as proof of this night, the only thing that the plaintiff puts forward is a photo of my client standing behind his own fence in the alleyway. And as the plaintiff just said himself, with regard to that night, he said that it was in the plaintiff's driveway. However, as exhibit C, there's just a photo of my client standing in front of the police cars. The plaintiff has also used this very same photo to try and make the court believe that my client was taken into custody, that my client was, apprehended.
Let's just kind of stay focused. So what is the basis of the stalking harassment? Was that because of the peeping Tom thing, or is that something else?
Well, so that's exactly it. It's just that it all comes from this July 25th night where
There's an altercation.
Yeah, he saw my client, and he basically came up to my client. I mean, without even any room for my client to move. My client tried, he's a family man. He has a child, a wife at home. And he's the guy that goes to bed at 10:30 at night. And so he's never been in a situation like this, has no priors, has never been in anything remotely close to a lawsuit like this. And so him afraid of what would happen, this being his first in-person encounter with Mr. Sorrells, he attempted to walk around Mr. Sorrells. And in doing so, Mr. Sorrells, as he is himself classified, decided to do a civil arrest of my client. That civil arrest of my client involved Mr. Sorrells placing his knee and sitting on top of my client with the police on the phone saying, hey, I just caught this guy. You got to come get him. And so my client actually couldn't see out of his right eye for 2 weeks. He had to go to the doctor because of the fact that his face was squished up onto the pavement so hard that it tore his cornea. That night, the police officer specifically asked my client, would you like to bring assault charges against him? Again, my client is a family man, never been involved in a situation like this, had, did not think about down the line when something like this might occur. He just wanted to go home and forget about the whole thing. And so I think it was like 2 months after that, after Mr. Sorrells had met with police officers incessantly, even taking it all the way up the chain to the councilwoman lady, is when out of nowhere, my client received a citation in the mail for assault. And so what happened was the plaintiff essentially decided that probably in teeing everything up for this lawsuit that he decided to bring, he would go and convince the police officers that, hey, maybe if I bother them enough, they'll find that there was an assault against me here this night.
Okay, I guess you still have it. I'm rereading your motion to dismiss. What does he claim that your client did to stalk him? Was it what is his allegation? It doesn't really say here.
Yeah, so he basically claimed that during his parties that he witnessed my client standing in the front yard. And again, this is after police had already been called to his loud parties as a result of the noise level of those parties. And so as any neighbor would, when you see car sirens and lights outside of your, coming into your home, you want to know what's going on in your neighborhood. You want to know if someone's been hurt, someone's been injured. And so what happened was my client walked outside and he had conversations on the sidewalk, on public roadways with police officers, with other neighbors. Hey, what's going on? Oh, this is crazy. Things like that. And so that's all that's on the record as far as in support of his stalking harassment claim.
Okay, so his argument or his allegation is that your client stalked him by talking to the police. That's the basis,
right? By talking to the police. I mean, if the plaintiff wants to interject here and provide or point the court to any other evidence, I'd welcome him to do so at this time.
All right, so Mr. Sorrells.
Mr. Thomas has climbed my 8-foot fence multiple times during the summer. He has come to my front yard and cat called across the yard. He's interrupted a meeting with the Dallas police officer that I had. The Dallas police have to come out to the calls of these defendants. And since I'm the only one that's been here, I'm not sure what I just heard, to be honest with you, but I did not pull Mr. Thomas out of his house, down the alley into my driveway, and then called the police. Mr. Thomas was there illegally stalking me through my fence with his phone camera and audio. He had done this on multiple occasions. The police had found him on another night hiding behind trash cans, which is alleged in my complaint. And I'm not sure what she's talking about as far as what the claims that just happened. I defended myself against Mr. Thomas. He panicked because he knew he was in the wrong in my driveway. And if he was injured, that is a result of his own cause of, I wasn't even touching the man until he came at me when I hung up with the 911 operator, at which point I took him down and the police detained him in my driveway when they came up in their police vehicles with their lights on, responding to this prowler call. They separated us, took him down, put him in front of their police cruiser where I got that picture from. And the officer that night issued it was called a miscellaneous incident report.
So your basis of your stalking claim is that he was kind of a peeping Tom, is what you're saying, and
Yes,
that
sir.
he, I guess he trespassed into your backyard. Is that right?
That's correct.
And that's the basis of that's at least part of the basis of your stalking claim.
Yes, sir.
So I guess, Ms. Salam, there's two separate issues here. One is, I'm not saying that I find Mr. Sorrell's story compelling or not compelling. That's not really the issue. The issue under the TCPA is, has bringing the suit violated a constitutional right of your client? Assuming that this is true, which is what we have to do, what constitutional right does your client have to go into the defendant's backyard or peep on his family?
Well, Your Honor, so again, the court is required to look at the pleadings and evidence on file. Okay, what's been presented to the court is plaintiff's verified petition where he alleges that my client peeped through the neighborhood. Okay, or peeped in the fence.
Is there something in the Constitution that protects people from that protects individuals' right to be a peeping Tom?
It does not, Your Honor. And so going back to the declaration, that was provided in the response, my client specifically negates this assertion, specifically negates this allegation. Moreover, in the only conversation I've had with plaintiff, I specifically asked plaintiff, did you see his face? Did you see my client's face? And he stated no. He said no. He said he saw a head peeping over the fence. My client has provided sworn testimony to this court that he's never climbed a fence. He's never climbed plaintiff's fence. Plaintiff himself has stated that he did not see my client's face. Also, he uses this peeping Tom allegation in support of his intrusion upon seclusion claim. In describing his intrusion upon seclusion claim, he claims that while he had all these party goers and his pool parties, that my client poked his head over the fence and it caused all of his party goers to feel so uncomfortable. Well, if everyone felt so uncomfortable, why didn't anyone take out their phone and take a picture? Why is there not one declaration, one sworn or unsworn statement on file from these police officers, from any one person at his party attesting to this? Your Honor,
this sounds like a great closing argument in trial, but I don't see how how you can say that there's a constitutional right to be a peeping Tom.
No, Your Honor, we don't think there's a constitutional right to be a peeping Tom. That's not our.
The purpose of the TCPA is to protect the exercise of constitutional rights. It's the right petition, right to association, right to free speech. I don't see how being a peeping Tom fits into any of those.
So the peeping Tom allegation again stems from the plaintiff having witnessed my client walking in the alleyway. He takes it one step further by trying to amount all of that to him being a peeping Tom and making false allegations. But again, our assertion is not in any way, shape, or form that my client has the right to be a peeping Tom. He does. Obviously, that's not a constitutional right.
Okay.
The right is to walk in your own alleyway and not have that's constitutional right is to walk in your own alleyway in your own neighborhood, to speak with other neighbors regarding things going on in your neighborhood without having a lawsuit filed against you. And so plaintiff has essentially put together, she's trying to make 1 + 2 = 100, 100 being all of these causes of action against my client, and that's just not the case. And so-
All right.
Okay, and so with that, in regards to the harassment claim, we've just gone over the pieces of evidence that have been put forth on that. And again, I would again like to reiterate that in order to, the burden does shift to plaintiff in order to prove each essential element of his claim. One of the essential elements of stalking harassment, which plaintiff has brought under 85.0031 of the Texas Civil Practice and Remedies Code, requires that as a result of the harassing behavior, the claimant reasonably feared for the claimant's safety. He has failed to state.
Again, how is this a TCPA issue, though? I mean, I get the argument. I understand that there may be a summary judgment. This may be, you were making an excellent closing argument there earlier, but I don't see how this is a TCPA issue. I just don't see where the constitutional rights. Now, I see it if your client made a police report. I get that. There's probably constitutional protection there. We can talk about that. But for a lot of this other stuff, I just don't see what the constitutional right that his lawsuit is. You may disagree with it. You may think it's subject to summary judgment. I just don't see how there's a constitutional right impacted by this.
So we were on the topic of the harassing claim. So we can move to the civil conspiracy claim and what has been put before the court with regards to the civil conspiracy claim at the time.
Okay.
And so with regard to the civil conspiracy claim, as Your Honor is fully aware, it requires that two or more persons came together for an object, to complete an object to be accomplished, a meeting of the minds on the object or course of action, one or more unlawful overt acts and damage as approximate result. Here, the only evidence that he puts forward, the only allegation he puts forward are that there were a few occasions where he saw my client speaking with another defendant, Mr. Clayton, on the front lawn. This is 100% a constitutional right. I mean, unless I'm some sort of confused, everyone has a constitutional right to stand in their neighborhood and speak with another neighbor. I mean, that's the right to association. And even if they were speaking about how this, it's a pure constitutional right. And so, with regard to the civil conspiracy claim, it should absolutely be dismissed under the TCPA.
And I think you had defamation and IED.
Yes, Your Honor. So for defamation, again, the real piece of evidence that that plaintiff has here, and he himself stated, is what caused him to bring the lawsuit, is this letter that was written by defendant Moore. Okay, he uses most of his second amended petition under his defamation per se cause of action to focus in on defendant Laura's letter. Nowhere on the letter does it have my client's name. Nowhere on the letter does it even indicate or infer in an alternate universe that my client had anything to do with that letter. And so with regards to defamation, what's been put forth before the court, I mean, defamation requires, the crucial elements are that defendant, there was a false statement of fact, each statement specifically referred to plaintiff, and the statements were defamatory. There is no published false statement here. There is no, he alludes to his party goers having been, cat calls, as he said. Again, Your Honor, my client's a family man. I mean, there's no cat calling. There's neighbors standing in front of their lawn saying, "Oh, wow, look at all of these people, these crowds pouring into this house, half dressed." I mean, just wearing a man thong, nothing but a man thong. And plaintiff's own
What did you just say? That wearing only what?
Wearing nothing but a man thong.
A what? A
I
man?
don't even know what that is.
What is that?
Underwear. Only one article of clothing covering covering the party goers.
Okay. I've never heard that term before, but okay.
And so it would just be a small piece of article of clothing that would cover.
Okay.
And so, and on these days, plaintiff lined, on certain occasions, plaintiff lined the entryway of his home with large signs with the words, come, C-U-M, written on them. And so for him to put himself out there like this and not expect for his neighbors to have conversations, and then him file a lawsuit as a result of those conversations stating defamation per se, it's so far removed from the requirements of what needs to be shown and for what is actually going on here.
Okay. Response, Mr. Sorrells?
I mean, where to even begin? She's trying to.
So tell me what the basis of your defamation claim is against Mr.
Yeah,
Thomas.
so Mr. Thomas and Mr. Allen would approach my guests and inquire to them, how are you getting invitations here? What are y'all doing in these drug-induced sex parties? We know what you guys do, what you gays do at gay-induced sex. These parties are nothing but gay sex and drugs. I did see Mr. Thomas's head peep over the fence. I'm sorry, I'm swimming and I don't have my phone to take a picture of him, but there was no man thongs walking down the streets. There are no come on in signs. They keep saying that the street was lined with this. They provide no evidence of this because there is none. There, you would think that something like that would jaunt a picture now and again. It's just a bunch of adjective-filled hoopla that I mean, I'm not quite understanding how you defend to this, but anyway,
what are you claiming?
Mr.
Sorrells, what are you claiming that they said was defamatory? That Mr. Thomas said was defamatory?
Drug-induced sex parties.
That he said that to your
For the guests coming in.
Okay, that makes sense.
Yes, yeah, and the police department. They were the lieutenant had to, tell them, look, you throwing around drug accusations is quite serious, and would you like that to be done to you?
Again, Your Honor, he's referring to Laura's letter when he talks about the drug accusations.
Well, I think he said that your client.
Yeah.
I think I'm not agreeing with this. I'm just saying he's claiming that your client told party goers that this was going to be some kind of drug party, is at least what he's saying.
Your Honor, what he said was that what he's alleging is that, and again, he doesn't even say specifically whether it was Clayton or Thomas. In his pleadings, he just says Clayton and or Thomas. There's two separate defendants, and they should be treated as such. And so what he says, his only evidence with regard to the defamation is that comments were made to party goers saying, sorry, was it, we know you're, I mean, how would they know anything that's going on? The party goers know what's about to go on. And so there's no false statement. There's nothing that's specifically referred to plaintiff. There's no, it's not defamatory. It hasn't caused the plaintiff any harm. It hasn't, none of this happened. And they're all essential elements. I mean, he hasn't even pled the elements of defamation with regard to Thomas.
All right. Anything else, guys?
And so, Your Honor, again, there are so many causes of action brought that there are two remaining: invasion of privacy, intrusion upon seclusion. It requires an intentional intrusion, physically or otherwise, and that would be highly offensive to a reasonable person. Again, Your Honor, he doesn't point to any specific evidence aside from his own, vague allegations of a head popping up over his fence. If there were so many people and if it was so highly offensive to a reasonable person, then why couldn't he find one person who was willing to write a statement, even sworn or unsworn, saying, I was highly offended by this person popping their head over? And yes, it was this person, Thomas. This hasn't been done. This has not been done. Moreover, in his second amended petition, he provides ring photos. At Exhibit G, the photos are of someone in a hoodie dropping something to his mailbox. When I asked the plaintiff how he knows whether it was this person here that popped his head over the fence, he said, well, he doesn't know. And so it's not fair for my client to be brought into this lawsuit when someone else, with regard to things that someone else did. And just because the plaintiff is deciding, oh, well, it would be better for my overall lawsuit if I said that, you know, he himself has said it was at the time that Laura's letter was written that he decided to bring this lawsuit. Okay.
Okay.
And so the last one, you know, again, with the invasion of privacy claim, there's no evidence of any kind whatsoever, not even a declaration. And the last one, which absolutely should be dismissed under the TCPA, is the intentional infliction of emotional distress. There are plenty of references to case law in our motion itself, to other cases that have been dismissed under the TCPA by way of, have been dismissed under the TCPA for intentional infliction of emotional distress, just because it is such a gap filler tort, and the elements, you know, require that it be so outrageous, and nothing of the sort has been provided. One of the examples I can think of off the top of my head that even comes close to intentional infliction of emotional distress claim is, you know, someone drowning their person's dog in the pool right in front of them to cause them emotional distress. And there's nothing coming close to that going on here. This is a family neighborhood who simply they just wanted to get some sleep, Your Honor. And
Let's just do this. There's a number of other attorneys here. I just want to see if anyone else, Ms. Nix, did you want to say anything, or Mr. Cook, or Ms. Shear? Any of you guys want to say anything?
If I could just add one thing, Your Honor, I represent Joel Thomas. With regard in particular to the defamation claim, the court is constrained to only the evidence that's in this record. And I think we've heard some things from Mr. Sorrells that are not in the record. And the record as it currently exists, and you're going to hear a motion to strike shortly, includes a late file response. But putting all of that aside, there's nothing in the written record that supports a defamation claim against Mr. Thomas. The record itself does not contain sufficient evidence to support that claim. And that's all I wanted to add. Thank you, Ron.
Okay, thank you. Mr. Shear, did you want to say anything?
Yes, Your Honor, if I may just
Remind me who you represent.
I apologize, Your Honor. I also represent Valerie Lohr with Mr. Brett Payne.
Okay.
And I would just like to make 2 quick points. The first being is that Valerie Lohr's 911 phone calls and discussion with the police officers are absolutely protected by the Constitution as her right to petition. I know Your Honor has received not only our binder, but also our response. And so I would just urge Your Honor to go look at our Harrington case, which is a 2020 case out of the Dallas area, which basically unilaterally states that such is the right to petition. And that not only that, but as an important constitutional right, because we want to make sure that people continue to express concerns. And as a result, there is a presumption that when someone makes a police complaint and then later on a malicious prosecution claim is brought against them, the presumption is that they did have probable cause.
Ms. Shear, I haven't seen the binder. When did you guys send that?
We sent it earlier this afternoon.
Okay. I'm not at the courthouse. Did it contain briefing for both sides?
Just our side, Your Honor. We did receive confirmation from your court coordinator. Really, all it was is that all of the motion dismissed, as well as our response and just 2 case laws, that we thought were really
I thought it was your response or your motion?
Our motion and then our reply to plaintiff's response.
But not their response?
No, Your Honor, we did not. Oh, actually, yes. I'm so sorry. I'm looking at it right now. It does include plaintiff's response.
Good. I
Okay.
prefer that. Perfect.
And
that was just the Thomas, but not the Lohr. Is that right?
Yes, Your Honor. I apologize. It was just.
Well, thank you for doing that. I appreciate you delivering that.
Absolutely. And your court coordinator confirmed receipt, and that I'm sure it's just somewhere in the email chain or box. And it does include this case. Like I said, it's the Harrington case.
I'll make sure to read that.
Thank you, Your Honor. And then, I'm sorry, I lost my train of thought. I believe that's all, Your Honor.
Okay, and Ms. Nix.
Yes, Your Honor. Thank you. I represent Mr. Allen. Mr. Allen represented himself pro se up until a few weeks ago when I filed a notice of appearance on his behalf. I am representing him pro bono. Mr. Allen is a disabled man with no real income. What I would like to say are two things. One, I understand that he filed a motion to join in the motions to dismiss filed by Ms. Lohr and Mr. Thomas. To the extent that you'll consider those motions, we continue to assert them. To the extent that you won't consider those motions, I'm happy to file an amendment before, I believe, his deadline, which is Friday the 15th, to file his 91A motion. And to the extent that anything that I could add to this proceeding on the petition.
It sounds like you need to file your own motion, and we'll deal with that.
I think so, Your Honor. I do.
Okay. All right. So let me tell you what I'm going to do. I'm going to take this under advisement. I'm going to get you guys a decision within the next 30 days. All right, guys.
Your Honor, I just, as I mentioned before, Brett Payne on behalf of Ms. Lohr, I think I'm required to go ahead and assert my objections. Number one, I would join with counsel in that, perhaps as a reminder, but also an objection to any statement made here today by Mr. Sorrell, which is evidentiary in nature.
I'm not considering, I'm going to decide this entirely on the record.
Great.
On the record that was submitted in the clerk's record.
Perfect. And so, Judge, let me first make that general objection that Mr. Sorrell's, his response in and of itself was not timely filed in compliance with the TCPA, and seek your ruling on that.
Is there any case law on that? That's a fairly new provision in the statute. So is there any case law on do I use the same standard you want in a summary judgment, or is there some other standard that we're supposed to apply here?
Your Honor, I kind of defer. I would defer to Ms. Shearer, but I'm not sure that there is or not. We're happy to brief you on it.
If you want to provide any supplemental briefing before this Friday, you can on that issue. My inclination is, if it's just a day late, it's to allow it. That's what I usually do in summary judgments, but that's not a ruling because I don't know what the case law or what the
Understood.
statute says.
And then the specific objections, we would object to the 61 items, paragraphs in Mr. Sorrell's.
You guys made that objection, and I'll take a look at that.
All right. And then specifically the unauthenticated photos and videos. Again, we specifically object to that and would seek the court's formal ruling on that objection as well.
Okay, I'll take a look at that as well.
Sorry, Your Honor, we would like to also join in on those objections. Specifically, we would point the court to 27.003E of the TCPA, which does require that plaintiff's response be filed not later than 7 days. The normal analysis under this, situation, in order for the court to consider whether or not to accept the late filed response, if it's along the same lines of just a normal motion to dismiss, would be a showing by the plaintiff of good cause for the delay. And I would, in that sense, I would like to point the court to a motion that was filed by plaintiff on the day that his response was due, which was an open court's challenge to the constitutionality of this statute that is made to protect constitutional rights to begin with. And so as far as the showing of good cause, unless I'm missing something, it appears that he spent his entire day diverting the court's attention to this notice of open courts challenge, only to realize on Tuesday that his deadline had passed. And then he came up with the response. And so I would say that there's no showing of good cause when he clearly had the time, ability, and resources to go ahead and file his response timely. And that
I'll take a look at that as well.
Thank you, Your Honor.
Your Honor, one last thing. I recognize the court based on some comments, perhaps I interpreted or misinterpreted. It seemed to me that the court's inclination is to distinguish the civil conspiracy claims as not being related. I would just like to point out or argue on behalf of my client that any type of civil conspiracy claim certainly as it relates to Ms. Lohr, arises out of her 911 complaints her complaint to law enforcement, and her letter to the landlord. So I do think it applies to Ms. Lore. And finally, I don't know if the court is inclined to hear it, but do understand, and as the court is well aware, the court can award attorney's fees. I recognize my firm is typically an insurance defense firm. This is not.
I will say this, that I'm fairly likely, though this isn't a ruling, but I'm fairly likely to rule for both of sides. I think some of these claims probably should be dismissed under the TCPA and some of them shouldn't. If there is a question about attorney's fees at that point, I'll probably have another hearing, but I'm not 100% sure on that, but that's kind of the way I'm leaning at the moment.
I understand, Judge. Just do understand that this is not my bread and butter covered by an insurance policy. These are real fees.
Well, it's an unusual case, and it does impact. I mean, there's a lot of interesting constitutional issues. I kind of gave Ms. Salam a bit of a hard time about is there a constitutional right to be a peeping Tom, but it does bring in some good constitutional issues, I think, that are impacted here. And so we need to kind of parse through each one and figure out what needs to be dismissed and what doesn't. What would be helpful, Ms. Salam and Ms. Shear, if you could email me a proposed checklist order for each existing current cause of action that you would like to consider me to grant or deny as to each one, because I'm probably going to grant some and deny some here. So if you could email my court coordinator and e-file those before Friday. Did you guys have any questions? Okay. All right, guys, we'll get you a decision before the deadline.
Thank you, Judge.
Thank you, Judge.
You guys be safe.
You too.
Okay, Tony, Rhonda, we'll see you tomorrow morning at 9. I need to talk to the interns about this. That was an interesting hearing. So we'll see you guys in the morning.
Okay.
And Rhonda, I think, can you ask Rhonda, did I already tell her or ask her to print out, I think I'd ask her to print out your email already, right?
I'll call her and ask her. I don't know.
Yeah, just she needs to print out the email and your attachments before Friday.
Alrighty. Will you be in the office Friday?
I'll be in the office on Friday. I'll be at the court Friday, but on right after this, I'm going to be driving to Houston to see my mom.
Okay. Is that hearing taking place Friday?
No, not this Friday. I don't think so.
Alrighty.
I think it's later than that.
Alrighty. Have a good
All right. Thanks, Tony.
Bye-bye.
You're still on YouTube.
Oh.
Judge.